This is Barry Zalma on insurance. Today I'd like to speak about the False Claims Act and the Qui Tam suit that results from such an action. The False Claims Act, also known as the Lincoln Law, dates back to the Civil War. President Lincoln signed the act into law in 1863. Because war profiteers were selling the Union Army shoddy supplies at inflated prices. The original law included Qui Tam provisions that allowed a private person, a plaintiff, to sue those who defrauded the federal government. If the suit was successful, the plaintiff would receive 50% of any recovery from the defendant. The Qui Tam provisions were weakened greatly as a result of congressional amendments in 1943, and Qui Tam legislation became virtually non-existent. However, in 1986, Senator Charles Grassley, a Republican from Iowa, and Representative Howard Berman, a representative from California, joined forces to amend the law and strengthen the incentives for citizens to uncover and fight fraud as Qui Tam relators. Relators are the private plaintiffs under the False Claim Act. The 1986 False Claims Act amendments received widespread bipartisan support and were signed into law by President Reagan. Since the revitalization, the Qui Tam provisions have increasingly been used, and used very effectively in health insurance and other type insurance fraud actions. The False Claims Act makes it unlawful to knowingly, 1, present or cause to be presented to the United States a false or fraudulent claim for payment or approval. 2, make or use a false record or statement material to a false or fraudulent claim. Or 3, use a false record or statement to conceal or decrease an obligation to pay money to the United States. Under the Act, private individuals, referred to as relators, may file civil actions known as Qui Tam actions on behalf of the United States to recover money that the government paid as a result of conduct forbidden under the Act. As an incentive to bring suit, a prevailing relator may collect a substantial percentage of any funds recovered for the benefit of the government. To establish a civil liability under the False Claims Act, a relator generally must prove, 1, that the defendant made a statement in order to receive money from the government, 2, that the statement was false, and 3, that the defendant knew the statement was false. The False Claims Act permits the federal government to recover damages and penalties against persons who knowingly submit false or fraudulent claims to the government for payment or approval. In addition, the Act authorizes a private citizen to commence and prosecute a civil action on behalf of the United States. The purpose of the Qui Tam provisions of the False Claims Act is to encourage private individuals who are aware of fraud being perpetrated against the government to bring such information forward. If the action is successful, the individual initiating the action is entitled to a portion of the recovery, and the Act sets forth the following procedure for Qui Tam actions. The relator must file the complaint in camera and serve the government with the complaint and written disclosure of substantially all material evidence and information. And this is before any defendant is served with the lawsuit or even made aware of it. The government then has 60 days to decide whether to proceed with the action. If the government decides not to join the action, the relator has the right to conduct the action on the government's behalf. The government may, however, intervene at a later date upon a showing of good cause. If the government does intervene, it assumes primary responsibility for the prosecution of the case and is not bound by any act of the relator. The relator remains as a party to the action, however, subject to certain limitations set forth in the Act. Specifically, the government may dismiss the action notwithstanding the objections of the relator, provided, however, that the person has been notified by the government of the filing of the motion and the court has provided the person with an opportunity for a hearing on the motion. Most Qui Tam actions seek to recover damages and statutory penalties for false claims made to the government by government contractors such as defense contractors and healthcare providers. A Qui Tam action can be brought for any government insurance program, such as the National Flood Insurance Program, Medicaid, Medicare, crop insurance, and state-sponsored earthquake or storm insurance. However, a Qui Tam action cannot be brought against insurers based on their claims handling practices. Similarly, in State of California versus Unum Provident, the insured and appellant sought to assert a claim under a California statute against a disability insurer. The Court of Appeal held that an insurer is not subject to a Qui Tam action based on its marketing and claims handling. As Unum Provident explained, taken as a whole, Section 1871 et sec. Is specifically tailored toward preventing and punishing the making of fraudulent claims to insurance companies. While originally limited to workers' compensation context, Section 1871.7 was amended in 1994 to extend its applicability to crimes involving fraudulent claims against insurers. The court said Penal Code Sections 549 and 550 are tools to combat insurance claims fraud perpetrated against insurance companies, and any person who engages in such insurance claims fraud is the proper subject of a Qui Tam action under Section 1871.7. To interpret the statute in the manner urged by the appellant would improperly alter the statutory scheme to enlarge its scope. California Penal Code Section 550, Subdivision B, penalizes those who present or cause to be presented any written or oral statement as part of or in support of or opposition to a claim for payment or other benefit pursuant to an insurance policy, knowing that the statement contains any false or misleading information concerning any material fact, or 2, to prepare or make any written or oral statement that is intended to be presented to any insurer or any insurance claimant in connection with or in support of or opposition to any claim or payment or other benefit pursuant to an insurance policy, knowing that the statement contains any false or misleading information concerning any material fact. Since the Qui Tam provisions were added to the Act in 1986, the U.S. Department of Justice calculates the government has recovered more than $1.09 billion in Qui Tam cases, with whistleblowers receiving nearly 18% or $184 million of the government's recovery. When considering a Qui Tam action, an insurer, an insured, or an individual should be certain, however, that the authorizing statute authorizes the action. For example, Allstate filed a Qui Tam action on behalf of itself and the state against defendants under the California Insurance Frauds Prevention Act, Insurance Code Section 1871.7. Following entry of the Qui Tam judgment, Allstate began efforts to collect it. During its investigation, Allstate learned of a series of real estate transactions conducted by defendants designed to transfer away their assets. Allstate, on behalf of the state, filed an action to set aside the fraudulent transfers of real and personal property. Allstate subsequently obtained a stay of the fraudulent conveyance action and returned to the Qui Tam court, where it filed a motion for an order allocating the Qui Tam judgment proceeds. The motion was based on a stipulation entered into between the people and Allstate, allocating to Allstate 50% of the civil penalties and assessments plus reasonable attorney's fees and costs. The trial court granted Allstate's allocation motion and entered the stipulation as a judgment. The defendants appealed, and the Court of Appeal held that the judgment debtor defendants in Qui Tam insurance fraud actions are not aggrieved by such allocation orders under Section 1871.7, with the result that they did not have standing to appeal. In People ex rel Al-Zayat versus Heb, a California appellate court held that as a true Qui Tam provision, Insurance Code Section 1871.7 does not mandate that the realtor has suffered his or her own injury. The court further noted that the lawsuit under Section 1871.7 was based on an injury allegedly suffered by the people of the state of California and was not filed for the purpose of remedying an injury suffered by the relator. This was People ex rel Stratham versus Acacia Research, a 2012 decision. The Act follows directly on the California statute, and Heb supports a finding that the Act claims are not restricted only to insurance companies or individual relators who have been personally injured. If an individual has knowledge that a false claim was submitted to the government, that person can elect to become a whistleblower and retain an attorney who will draft a complaint and a disclosure statement. The whistleblower will file these two documents under seal in U.S. District Court and send copies to the Department of Justice. After the complaint is filed, the Justice Department reviews it up to 60 days, and if it joins the lawsuit, it maintains primary responsibility for pursuing the lawsuit. If the department decides not to participate, the whistleblower has the right to continue to pursue the claim. The False Claims Act states that any person can file a Qui Tam action as long as they have direct, independent knowledge of the fraud, and this knowledge was not obtained from a public disclosure. Therefore, any insurer with an effective special investigative unit that gathers evidence of fraud can file a Qui Tam action against the fraud perpetrator and can receive a portion of whatever the state recovers from the fraud perpetrator. This may be a different way than trying to get the state to prosecute the criminal act of insurance fraud, and will have a chilling effect upon those who wish to perpetrate the crime of insurance fraud against insurance companies. It is a tool, not a requirement. And the whistleblower must understand that the Qui Tam statutes make it expensive to an employer to retaliate against the employee whistleblower or against the insurer whistleblower if it can be proved that, for example, an employer has taken any adverse action against the employee may seek compensation from the employer. Besides the False Claims Act, there are a number of other statutes that offer protection for whistleblowers. Such statutes include the Civil Service Reform Act, the Fair Labor Standards Act, the Occupational Safety and Health Act, the Employee Retirement Income Security Act, Title VII, Equal Employment Opportunities, Age Discrimination in Employment Act, Civil Rights Claims, National Labor Relations Act, Federal Whistleblower Statute for Employees of Defense Contractors, Federal Deposit Insurance Act. All can protect the whistleblower for making a claim of someone trying to defraud the state, or in California, defraud an insurer. This video was adapted from my book, Selma on Insurance Claims, Part 109, Second Edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found the video to be useful or interesting, please pass it on to your colleagues, and please also subscribe to my YouTube channel, my Rumble channel, clicking both on the link or the Rumble places on the website so that you can show your appreciation for the videos. Please also subscribe to my blog and my Substack publications so that you can learn about future videos, articles, and videos. Thank you for your attention.